Levels Academy Islamabad. In this video, we will understand how to solve the law paper. This is the law paper of Paper 1 English Legal System. The code is 9084 with the variant 12. May-June 2023. So I'm going to start directly from the questions. I'm going to go to the questions. So here we have section A. Section A has shorter question including the longer questions as well. So the first question of this paper is identify two examples of moral belief. So this is our first question. Let me take you to the marking scheme. So here we have the marking scheme. So I'm going to go straightly to that particular answer that we had discussed earlier. Here it is. So this is the marking scheme. So here you can see that the question is written here like identify two examples of moral belief. Right over here there's more than two examples. It is like 1 2 3 4 5 6. There are total 6 moral beliefs available here. So what is the thing you have to do is that you don't have to write directly like the same way as written in the marking scheme. Instead you have to write an answer in a different manner where you have to include these points. If they're asking for 2, so you have to add any of these 2. Okay, so let's see the answer. Moral belief are ideas about what is right and wrong in our society. Ultimately, these beliefs make rules and regulations. So basically, in the first line, you have to explain what is moral belief. So you have to say that moral beliefs are ideas about what is right and what is wrong. So obviously, we all know that if something that is right is obviously a right thing to do, and if something is not right, it's visibly seen that something is not right, that thing is considered as moral belief. We will also discuss the examples so that you can understand what moral beliefs are. I have included 2 examples here. First example is being honest is considered a positive moral belief. So this is the first example over here. Let's see the other example. Another example of moral belief is stealing. That is wrong. So you can see I have written 2 examples. The first example is about being honest. Second example is about stealing. That is considered a wrong thing. Okay, so this is also a second example over here. It should be punished at all cost. Hence, originating from this stealing becomes an offense by law. So basically, first of all, you have to give first example like being honest in just one line. But when you're trying to explain another example that is about stealing, you also have to elaborate that stealing is kind of like a bigger offense. It is really bad thing to do. So this type of offense must be punished at all costs. So you have to write few more lines more about a particular example if you think that it should be discussed more. Okay, so that's the reason I had included more lines of stealing like that. Okay, similarly, murder is also considered an wrongful act and hence it is also punishable by law. Even though they asked only 2 examples, yet I have added more than 2 examples in case if one of my example get rejected or get maybe it could be not considered right, then at that point it's better to include one more. Even though they're asking only for 2, yet you have to add more than 2 just in case for the safety. Okay, so this is how you have to add the whole answer where you have added different examples. So I'm going to repeat the example. First example is being honest. Second example, stealing. Third one is murder. So let's see the marking scheme. Marking scheme also had it murder. It was like not to kill others. This is a part of the murder. Let's see the other one, not to harm others, not to steal. So I've added this as well, stealing. Let's see the other ones. Also tell the truth, do not cheat, do not disturb property. So always tell the truth is a part of being honest, right? So even if I did not wrote the exact wording of the marking scheme, still the wordings I have mentioned in my answer are a part of the marking scheme. This is how you have to write your answer as well. you don't have to completely change your answer. Instead, you have to use wordings like these to match the marking scheme and to match the answer they have given. Okay, so this is it for the first question. Let's see the second. Okay, it is identify two roles of a barrister. So in this question, you gotta write the two main roles of a barrister. So these are the roles of a barrister. So I'm going to repeat the same line. If you're writing your answer, make sure that your answer is like resembling the marking scheme, yet it should not be completely like the marking scheme. You don't have to like as it is copy paste the marking scheme. Instead, you have to make your answer a bit more changed while writing it. Let's see the answer I have written is first most important role of a barrister is advocacy. In the first line, I have written about advocacy that the main role of advocate or a barrister is advocacy. Second line is which means speaking on behalf of a client in legal matters in a court. First of all, I have explained in the first line that the barrister's main role is advocacy. Now in the second line, I have explained about the meaning of advocacy. So advocacy means speaking on the behalf of a client on legal matters in the court. This is called advocacy. Advocacy also means that they use their skills to present arguments clearly. So basically, how I written the answer is that I have mentioned about advocacy, that this is their main role. After doing this, I have explained about advocacy on two lines. This is how you have to write your whole answer, in which you have to first of all write the role, and then you have to write the meaning or explanation of that particular role. Then I'm adding the second role. The second role of a barrister is to maintaining confidentiality is an important quality of a good barrister. They keep all information shared by their client private and not revealing it to anyone without permission. So from here to here, the whole answer is on the same role. So basically, in the second line, I have mentioned about the second role. In the second role, I said that barristers have a role to maintain confidentiality. Basically, if a client, suppose this person is a client and this other person is a barrister. So the client is telling the barrister about all the detail of their particular case. But sometimes client also share a lot of things to a barrister related to their client that could be a little embarrassing if these information that is given to the barrister, if the barrister had told everything to the court, whatever that had been spoken by the client, ultimately what will happen is the client's reputation may be damaged. So in this situation, the barrister has a duty to not to reveal all the things that are discussed between their clients. Instead, a barrister should know how to represent the client's case. So basically, if a client over here is telling anything to a barrister, the barrister should know how he should talk in court, how he should represent his client, and what are the things he should be discussing in the court. So these are the things that's the reason it is mentioned here that the barrister should maintain confidentiality, all the information of their clients. This is the second most important role of a barrister. They should not leak or share any of their clients' private information, nor reveal it without their permission. Also included the third role as well. They also do drafting. Drafting is basically the third role. They only asked about two, yet I have included three. Why? Because maybe if examiner might consider my first role not good, so maybe he could consider the other two valid, or maybe the examiner will consider my drafting a not good role. Instead, the examiner might think that advocacy and maintaining confidentiality would be a better role. So in this situation, I don't want any confusion in my answer, so I have included more than three roles. So this is how you also have to include your answer as well. So in the third role, I have included about the drafting, that the barristers do drafting of their legal documents such as pleading and writing arguments. which are used in court to support the client's position and help judges understand the case. So basically, in easiest word, I will explain what is legal drafting. So legal drafting is basically a page in which the detail of the case is mentioned about the client, where there are going to be legal words used in that paper, and the detail of the client's information will also be mentioned in this draft. So this draft over here will be called as a draft, and this draft will go straight to the judge as well, and to the opposite lawyer as well. That will help the lawyer as well as the judge to understand the case of their clients. These are the basic main roles that had been discussed here. So now we will see the marking scheme, but before going to marking scheme, I'm going to highlight the roles. The first one is the advocacy, second one is maintaining confidentiality, and the third one is the drafting legal document. We will match them with the marking scheme. We have more than two roles. So the first role is representing client in the court. As in the first line I have mentioned about advocacy. In advocacy we have mentioned that a barrister represents their client in the court. So it was mentioned in the first line. So the second one, I'm going to tick this because I have included it. Second is drafting advice. I did not mention this. And the third one is writing opinion on the case. I also didn't mention this. Third one is drafting documents for client for the court. Yes, I have mentioned this in the last line. And then we have being employed by the civil service. I did not mention this. And the last one, being employed by the CPC. So basically I have mentioned two most important roles from here, that is representing the client to the court and drafting documents. So this is how I have included my answer, but I did not added the same wordings of the marking scheme. Instead I have added these lines that are mentioned in the marking scheme, but I also had explained them as well in order to get the full marks that are given. So the third question is going to be a little longer as compared to the previous ones because it is for 5 marks and it will be longer. And the reason for it to be longer, because this answer is based on bills. Bills is obviously the longest one. It has different stages. So let's read the question carefully. Then we will see the marking scheme. At the end we will see the answer. So the question is, identify 5 of the stages a bill must go through to become an act of parliament. It is telling you to identify 5 different stages where a bill goes through in a parliament. So this is the question. So you don't have to write 3 stages or 2. Instead you have to write all the 5 stages of the parliament. Now we will see the marking scheme and then we will see the answer. In question 3 we have all the stages available here. Let's count them. We have 1 2 3 4 5. Basically a lot of students might think that ending the answer to the third reading is the correct way to solve this. This is not the correct way. Instead, if you want to score full marks in this question, you have to complete all the stages. You don't have to write all of this as it is in the answer. Instead, you have to explain all of these stages. So how you have to explain them, I've written down the answer. You can also see that this answer is kind of a bit longer than the previous one. It's going to end to here. It's going to start from here and will end to here. So let's see every point that is written down. So first of all, you have to give a little bit of definition about parliament and what it is and what role it performs. So first of all, I've written is parliament is the highest lawmaking body in UK that has 2 houses. So basically in the first line I have explained that parliament is the highest body that makes laws in UK. You have to mention this as well. Secondly, I have included that parliament has 2 houses. Now you don't have to skip the names. No, instead you have to mention the name of both of these houses in your answer. After telling that there are 2 houses, now you have to tell that what are the names of those houses. So you have to include the names, that is House of Commons and the House of Lords. Both of these houses are the houses of parliament. Both houses have 5 stages. Law is made after passing from these stages. In the first reading, a bill is introduced by its name and the person name who is introducing the bill. So basically, you have seen it clearly that I have mentioned about 5 stages. Although in the marking scheme there were more than 5 stages, there were more than 5 points, but I will include 5 stages, but I will also include those extra points in the marking scheme at the end. But how I will include it, you will see this in this video. First of all, you have to tell about the parliament, then you have to tell that parliament have 2 houses, you have to include their names. After doing so, you have to tell that these houses, both of them have 5 stages. After doing that, you will start telling that law is only made if it is passed after crossing these 5 stages. After doing this, then the second line or the next line you will start is going to start straight from the first reading. First reading is basically the first stage, but you will not write the name of first stage. Instead, you will write the name of first reading. This is the correct alphabet to use because this is the correct name for applying it. So after writing the first reading, you will continue your answer by explaining about first reading, what happens in the first reading, how it is done. So basically in the first reading, a bill is introduced, and that bill is introduced by the name of the bill. Like if it's a tax bill, it should be named as a tax bill. If it's any kind of a bill, it should be named as well. After doing this, that the person who is representing this bill, his name is also going to be added with that bill, and that bill with name is going to be introduced in the parliament. And when that bill is going to be introduced, no voting or reading will take place. So all this detail is about first reading. If you did not mention all this detail, you will not get full marks. If you only write the names of the stages, you will barely get 1 or 2 marks. They will not give you full marks for the things you did not mention. So you will have to mention about the detail that is occurring in the stages. So the first stage is first reading, and you have to tell that the first reading is a part where a bill is introduced with its name and the person's name, and here no reading or voting is done. So you also have to mention this line in order to get full marks. Now I will move to the next reading. So the next reading is the second reading. You can see I am not messing up my names. I am not writing second stage or second step. Instead, I am writing the correct names that are suitable to use. So the first one was first reading, second one is second reading. I am circling these because these are the main thing you have to remember. Okay, so the second reading, after writing this, then you have to tell what happens in the second reading. So basically in the second reading, debates are done on the bill, and voting is also done at the end. So basically different people are going to sit in the second reading, and they're going to discuss on the bill. They will talk to each other that what are the things in the bill. They will vote on it. So all of this thing is going to happen in the second reading. You don't have to write that much. Instead, you will just write that debates are going to done on the bill and voting is going to be done at the end. After doing so, this bill will end from this and go to the next stage. Okay, so basically when the bill got introduced from first reading, it will go to the second reading, and in the second reading, debates will be done on the bill and voting will be done. After crossing from the second stage, the bill will reach to the committee stage. In the committee stage, the bill gets examined by the committee, where few people are going to sit and check all the different clauses and different points mentioned in the bill. So this is done in the committee stage. As you can see that I am not skipping the detail of the stage. I have included about the stages, but I'm also including the details of the stages, that what will happen if a bill reaches these stages. So you also have to include these the same way I have included in this answer. So when the bill shall reach to the committee stage, the bill gets examined by the committee, where the committee shall check each clause of the bill and vote on it. Okay, and add amendments in it. Amendments means changes in the bill. So basically when the bill reaches to the committee stage, then the committee will check the bill and may vote on the bill and may apply some changes on the bill, that they will consider that few clauses are good, or maybe they should think that it could be changed. So these things are gonna occur in committee stage. Okay, then pass to the report stage. So basically after completing the committee stage, the bill will go to the report stage. So you should not write fourth stage or fifth stage. Instead you have to memorize all of these stages name, like report stage, committee stage, and the first reading, second reading. You have to memorize them the same way. So when it reaches the reporting stage, the bill is reviewed again. So basically it had been reviewed earlier, but even is reached to the reporting stage, it should still be reviewed again. Review means checking the bill again, checking all the clauses again, debating on it again, voting on it again. This all thing means reviewing the same bill. So the bill gets reviewed and debated and been voted on the report stage again, and including any amendment during the committee. So basically when the bill reaches to the reporting stage, here all the clauses and everything gets checked. Even those amendments are also being checked that were being amended in the committee stage. Basically if the bill reaches to the committee stage applies few amendments or changes few clauses of the bill, those clauses will also be checked on the report stage. But if there is no amendments or changes occurred in the committee stage, no amendments had been done, then report stage will have nothing to check about the amendments. It will only check the bill because there is no amendment made. When the bill and all the amendments are properly checked, then that bill is sent to the House of Commons. Suppose the committee stage have applied few amendments, then that amendment including the bill is going to the reporting stage. Reporting stage is also checking the bill and the amendment. Then what will reporting stage will do? Reporting stage will do is that it will send that bill again to the House of Commons to vote on the bill again, because there were amendments in it. How does amendment occur? Because of the committee stage. Committee stage have checked the bill and they thought that they should add more changes to those bill. And when the committee stage added those amendments, added those changes, that's the reason where the bill goes back to the House of Commons, where everything goes to the back and starts again from the first reading. So if there is no amendments or no changes, then the bill will not go back to the House of Commons. Instead, it will go straight to the third reading. So here, if no amendments are done, then the bill is sent straight to the third reading. Third reading is kind of like a final reading where there is a final voting, and the bill then is sent straight to the House of Lords. So basically when the bill reaches the third reading, it's obviously clear that it is the final stage, and now the bill is going to be finally voted. After doing the final vote, the bill goes straight to the House of Lords, and when the bill reaches to the House of Lords or goes to the House of Lords, the same 5 stages are also available in the House of Lords, and the bill, after crossing the House of Commons all stages, it will go to the House of Lords and also go through all of those 5 stages again. Okay, so if this bill gets rejected in the House of Lords after coming from House of Commons, then what will happen is that the House of Lords will send back the bill again to the House of Commons, and this will happen several times. Okay, but if the House of Commons and House of Lords, both of the houses are agreed on this bill, then what will happen is that at the final stage, this bill gets the royal assent. Royal assent means getting the signature or the sign of the king or queen. After getting their sign, that bill becomes a law. Okay, so basically in the royal assent, where a royal king or a queen signs the bill, after this bill becomes the act of parliament. So in the last line I have included that after the bill gets signed by a king or a queen, then that bill becomes the act of parliament. Act of parliament means law. You can also write law, but I think act of parliament is more better abbreviation to use in UK. Okay, so this is how you have to include your answer. So as I am going to repeat it again, that I did not included the same marking scheme wordings in it. Instead, I have explained every stage. So let's see the marking scheme. First reading, second reading, committee stage, and all that. If you only wrote their names in the paper, barely you could get 1 marks. Barely you can get 1 or maybe 2. If you only write their names, you might get only 1 marks. But if you write it the same way as I have written, where I've explained about the first reading, the second, the committee, I've explained all of these. So this is the correct way to get full marks. If you're going to explain everything in detail, then you will surely get full marks. But before writing about these stages, you also have to mention that what is parliament, what type of role of parliament has. Is it a law-making body? You have to mention about it. You have to mention that parliament has 2 houses. You have to include the names of the houses, and you also have to include every detail of these readings as well. Fourth one is describe the 3 classification of criminal offenses. So here they're asking you to describe 3 classifications of criminal offenses. We all know the 3 offenses, but I'm going to explain that answer. But before going to my answer, we will see the marking scheme of this 4th question. Here we have the 4th question down here. So in this 4th question, what are those characteristics? So first one is summary offense, second one is indictable offense, and terrible either way offense. So basically, if any of you only memorized their names and you did not mention any detail of these offenses, you just wrote their names in the answer, you will barely get 1 or maybe -1. Okay, because you don't have to, as it is, copy paste the marking scheme. Instead, you have to explain about summary offense, you have to explain about indictable offense and either way offenses as well. If you have explained them properly in your answer, then you will get 4 marks. In this answer, you can see that I have written that there are 3 classifications of criminal offenses, the same way that is mentioned in the question. Like in the question, it is also mentioned that explain or describe 3 classification of criminal offenses, the same way I have included it in my answer as well in the first line. After writing this, that there are 3 classification of criminal offenses, I will start with the first one directly, but I will not include the other remaining offenses in the start because I want to clarify the first one. Basically, what I will do is that I will write the first offense and I will discuss it in this whole paragraph to here. After doing so, in the next paragraph, I shall discuss the next classification. This is how I will explain the answer. So after writing that there are 3 classifications in the first line, then I will write the first one is the summary offense, which is tried in the magistrate court. So then I will write the name, that is the summary offense, which is the first one, and I will also mention that the summary offense is tried in the magistrate court. Then I will say that these offenses are minor and their sentences is also minor. Summary offenses are divided into different levels, where first level is the lowest and the 5th level is the highest level. These levels define that how much maximum fines should be set on each offense. Level 1 has £200, which is considered summary offense, whereas we can see the example here that summary offenses include assault, theft, shoplifting, driving while disqualified. So this whole paragraph basically discusses only about the summary offenses. Summary offenses was the first classification of criminal offenses. Summary offenses are tried in magistrate court. After writing this, then I have discussed that these offenses are very minor. They are not that much severe offenses, and these offenses are divided into different levels. The first level is the lowest, that is, it is not that much severe, and the 5th level, obviously the 5th level is the highest level, where there are highest level of offenses. And these levels define how much or how much fines or punishment should be imposed on the crime committed by a person. So this level defines the offenses. The level 1 imposed 200 fine on the criminal that committed the offense, and basically this was the lowest amount that can be imposed, and this type of amount is only available for summary offenses. There are a few other amount and few other things also available, but you can add only one or you can add more if you remembered more. Okay, after writing the amount, after writing that this is a minor offense, then you have to give example as well. You have to give example of these minor offenses of summary offenses. So basically theft is a summary offense and shoplifting is also a summary offense. Then we have driving while disqualified is also a summary offense. Let's see the other one. So the other classification is the triable either way offenses. These offenses are more serious offenses and are tried either by magistrate court or crown court depending on the factors. That most serious one may go to the crown court, but the other which are less serious may go to the magistrate court. If the defendant pleads guilty, the magistrate court has the power to hear the case and sentence the defendant, as long as the offense is not too serious for the magistrate to deal with. If the defendant pleads not guilty, the magistrate court will decide if the case should be transferred to the crown court for trial. This depends on the seriousness of the offense. The defendant has the right to choose to have the case heard in the crown court, even for less serious offenses. This right is important because the crown court has more extensive powers in terms of sentencing. However, the defendant cannot always choose to go to the crown court if the magistrate court believes it's not necessary for the case to be heard there. For example, it includes assaults causing actual bodily harm, theft, and burglary. So basically, this whole paragraph you have seen is all about the serious offense, which was called as the either way offense. So basically the either way offense is more serious compared to the previous one, and this type of offense can be tried in magistrate court as well as crown court, but magistrate courts mostly deal with less serious offenses as discussed earlier, but in crown court the case should be more serious. Suppose if magistrate court is dealing with a case that is less serious, but if there is another case that is more serious, then magistrate court will do is that they will transfer their case to the crown courts, because crown courts have authority to deal with the triable either way offenses. You have to explain all of this. After telling about the seriousness of the crime, then you have to mention the courts like magistrate court and the crown court, and you have to also mention that magistrate courts deal with less serious offenses whereas the crown court deal with more serious offenses. Okay, if the defendant is guilty, then the magistrate can impose sentence on the defendant as long as the offense is not too serious. But if the offense is really serious, then the magistrate court will do is to transfer that case to the crown court in order to give that defendant more serious imprisonment or more serious fine, because the crown court has more power of giving imprisonment as compared to the magistrate. Okay, so you have to add all the detail like that. Now moving on to the third one. The third classification is indictable offenses, which are the most serious offenses, which can only be tried in crown court. Example includes murder and rape. Obviously, this third one is the most serious one, and in this type of offenses, it involves murder and rape. And obviously, murder and rape itself is a really serious or severe offense, and such type of offense can only be tried in crown court. It can never be tried in the magistrate court. Okay, these offenses have harsher punishment and life sentences. Obviously, if someone commits murder, these two are the types for the indictable offenses, and these type of crimes are really harsh, and these type of crime have harsher punishment as well as a lifetime sentence. Next question. Discuss the disadvantages of using lay people as jurors and magistrates in the criminal justice system. So in this question, you have to discuss that what are the disadvantages of using lay people as juror and magistrate in the criminal justice system. So let's go straight to the answer. I have opened up the answer. Let's read and understand what is the answer for this question. Lay magistrate and jurors are a part of the justice system since the Justice Act 1361. They provide assistance in criminal cases and give sentence. However, they are not legally qualified, which is a disadvantage of using lay people in criminal justice system. As you all can see that I did not directly mention their meaning that they are not legally qualified. I did not mention that directly. Instead, first of all, I have mentioned the act and that these people like these lay magistrate and juror have been a part of the justice system since 1361. Okay, so this is basically the act that was made in 1361, and due to this act these people were a part of this system. Okay, so you have to mention this act itself will give you 1 marks. Okay, or maybe more than 1. So after doing this, you have to tell that what type of work they perform. Obviously, they're magistrates, so they will perform assistance in criminal cases and they will give sentences. But after doing this, after adding the act, after telling their powers, then you have to tell that they are not legally qualified. This is the disadvantages you have to add. But a lot of you might be thinking that why cannot I add about their disqualification in the start and skip the act? No, the act itself is going to give you a boost. Basically gives power to the lay magistrate to perform their duty in court. Okay, so because of this act, these lay magistrates and jurors are working in criminal justice system. Without this act, maybe they can't work. So that's the reason they're working in their system. Okay, so due to this act, they're present there. And that's why this act is really important to apply in this answer. This will give you good marks. After doing this, you have to tell that what type of powers they have. They work on criminal cases and they give sentences. Then you have to explain this power. After doing all that, then at the end you have to tell first disadvantages, that is that they are not legally qualified. After doing all that, then you have to write a second paragraph that should start from a different line like that I have written. Due to their lack of expertise, they will take absorbed decisions and be able to keep a neutral mindset. So basically, in the second line, I have written that due to their lack of expertise, whose lack of expertise? Lack of expertise of the lay magistrate and jurors, right? Due to their lack of expertise, they will lack observed decision and will not be able enough to make a neutral mindset. Instead, they will become more biased. Okay, so being biased is not a good thing. Magistrates should be neutral people. They should not take anyone's side. This is the most important thing. But they lack the expertise, they lack those experience. That's the reason we find it a disadvantages to use them, because they lack those main things. What they lack is that they cannot be neutral minded. They can take anyone's side. Okay, and they will not focus on law. Instead, they will take anyone's side. That's the reason we see a big disadvantage in them. As seen in the R.V. Young Stephen 1995 QB 3-4 case. So basically you cannot write only the R.V. Young Stephen. Instead, you have to mention the whole case like that, the way I have mentioned it. And after mentioning the case reference, then you have to tell that what happened in this case. So basically in this case where the jury used the Ouija board trying to contact the spirit of one of the victims to find out if Young was guilty. And after the trial, it came to light that the Ouija board's sense had influenced the juror's decision. Young appealed his conviction on the grounds of jury misconduct. So basically, Mr. Young over here was guilty of an offense, but the jury, instead of using law, it used Ouija board to solve the case, And that is kind of like not a good thing to use in legal system, because it's obvious that using such type of things is a nonsense. It is not considered a right thing to give a decision. So basically, when Young knew that their judge is using Ouija board to contact the victim, ultimately Young did is that he appealed the decision of their jury in another court, and that appeal ultimately made the decision of the lay magistrate wrong. That's the reason that these lay magistrate lack the most important experience that normal judges have. So you can add this reference in this. So basically this case is very important because this case helps boost marks for your exam. So basically how you will get marks, you will get marks from this act. Number 1 point is this. Second point, you will get marks from the powers that lay magistrate have. These are the powers that they work on criminal cases. They give sentences. You will get one more marks from here. The other marks you will get is from this portion of lack of expertise, but you will get marks from lack of expertise if you will add a case law with it. Like case law basically boost marks. Maybe you will get direct 2 from here. It depends that if you are not adding any case, then you might not get that much marks. But if you're adding a case and explaining the case properly and relating this case with your answer, then it will help you a lot in getting good marks. Let's see the other paragraph. Another disadvantage is being biased as seen in the case of law R.V. Bingham Justice, ex parte Jowett, 1974. So basically we see another disadvantage here is that these lay magistrate and jurors can be biased. And we saw a case over here, and in this case we will relate it with being biased. So how this happened is that where a magistrate openly said he trusted police officers more, showing possible bias. This is miscarriage of natural justice system that shows the disadvantages of using lay person. So basically here in this case what had happened is that the magistrate basically openly said to everyone that he trusts the police officer more. This trusting the police officer itself makes the case biased, because the judge here is not being neutral. Instead, he is being biased and supporting or taking the side of the police officer. So this case is a big help to boost your answer. Furthermore, they are unable to handle more complicated cases, which make it a disadvantage. So basically in the last line you can say that these lay magistrate cannot deal more complicated cases. So this is also another disadvantage you can write. So I only added 2 cases. If you want to boost your answer, you can add more than 2, but I think 2 cases are enough to get full marks. So whenever you're trying to write your answer, make sure when you're adding a case, that case should relate to the paragraph. Suppose if you're writing about lack of expertise, you should mention the same case that will relate with that disadvantage, right? The same way, if you're talking about bias, you should mention the same case that relates to the disadvantage. To the next question. So the next question is section B. Let's open the paper. So the next question is in section B. Section B mostly has the longer questions. So the first question is question number 6A. Explain the powers of Court of Appeal to depart from an otherwise binding precedents. Let's see this other question. Discuss whether the Court of Appeal should be able to depart from decisions of the Supreme Court. So here you can see one thing common is that when you're attempting question 6, both of the questions that are available in question 6 are similar, but when you are writing the question, there are going to be bit differences. I will show you the differences in my answer. Let's open the answer. We have the written answer here. I'm going to read it and explain to you everything in detail. Court of Appeal is the main appellate court for both civil and criminal cases in the legal system of UK. Court of Appeal deals with appeals from aggrieved parties. So you can see here that they are not basically asking for explaining the Court of Appeal. Still, I have explained about Court of Appeal. In the question, they're asking you about the powers of Court of Appeal. But I have written also about the Court of Appeal, that what it is, what role it performs. Why I did this? Because this whole answer that I started contains 1 mark, because examiner will notice that do you know about the Court of Appeal. They will look at what type of answer you will portray in your exam paper, because they will give you questions like this, but they will also notice that do you know about a Court of Appeal, do you know what function they perform. So if you write down in the first line about the Court of Appeal that these Court of Appeal are the main appellate courts in UK legal system, if you have written down this thing very clearly, then you will definitely get 1 marks from writing this. And you should also mention that these courts deal with appeals, and these appeals come from the aggrieved parties. Okay, furthermore, you also have to mention that Court of Appeal, according to Lord Denning, is not bound to follow previous decisions as mentioned in Young versus Bristol Airplane Company Ltd 1944. So basically, if you would add about Lord Denning, it will also boost 1 marks. In 2 methods you will get marks. First of all, when you will write about Court of Appeal, that Court of Appeal is the main appellate court. It deals with both civil and criminal cases in UK, and all the appeals that come in this court are from the aggrieved party. This whole point is going to give you 1 mark. Besides this, the other point you will get from the Lord Denning, because Lord Denning plays a very important role in Court of Appeal. Court of Appeal, according to Lord Denning, is not bound to follow previous decision as mentioned in Young v. Bristol Airplane Company Ltd 1944. So basically, in this case that I have mentioned here Lord Denning had said that Court of Appeal is not bound to follow their previous decisions. It stated that the court can depart from its own previous decisions that are conflicting if there are 2 previous decisions that are conflicting with each other. So basically, why did Lord Denning told us that the Court of Appeal is not bound to follow their previous decision in this case? Because in this case, Lord Denning had highlighted that these courts, such as Courts of Appeal, do not need to follow their previous decision, because if their previous decision is conflicting, suppose there is a decision that Court of Appeal have given in 1998. Later on, the same court have given another decision in 2025. So what will happen is that both of these decisions might conflict each other. They are the same ones. The cases are same, yet their decisions are being a little different. They will conflict with each other. This is the reason Lord Denning said that Court of Appeal is not bound to follow their previous decision that occurred in their past. So this thing is highlighted in this case, because in this case it was highlighted that Court of Appeal does not need to be bound to follow their previous decision. Okay, next paragraph, I had mentioned that for the pre incurium cases, it was pointed out in Records versus Records 1989. In this case, the court allowed an appeal even though it was made after the deadline, because an earlier decision had been made per incurium. So basically, in this whole paragraph, you will get 1 marks. Why? Because in this paragraph, I have added about per incurium cases. Due to these per incurium cases that had been also available in Records versus Records case law, so you're not only going to mention per incurium cases, you also have to mention these case law with it, because this case law is connected to per curiam cases. Because in this case law, what had happened is that the court had allowed an appeal because the decision that was made was per curiam. Because suppose why this whole line had said that appeal was allowed even after the deadline, because there was a person who had given a decision who had went to a court and wanted a decision for their case. So they went to the court, but the decision was per curiam and they don't like the decision because there were few flaws in the decision. Due to this person decided to go and appeal on this decision, yet this person was too late and too lazy to go to court. Still the other court had accepted their appeal and said that yes, we will help you out and give you another decision, because the court had realized that the previous decision was per curiam and it was not suitable for them. That's the reason and they had helped them out, and this occurred in this particular case. So the thing I have told you about this particular person, what was occurring in this case of record versus record in 1987, it was a per curiam case. Per curiam means lack of knowledge, lack of adding the particular laws, lack of adding the facts. So basically per curiam is a combination of something that has been lacked, is a combination that something is missing. It's like in the decision there's a bit missing of law, a bit missing of facts, right? So these type of cases or decisions are called as per curiam, because there is a lack of something valuable that should be mentioned in this decision or in this case. Okay, so this is called per curiam. Now I'm going to the next point. Lord Donaldson explained that although the Court of Appeal must usually follow its past decisions, it can refuse to do so if the earlier decision was clearly wrong, which is made without considering important laws. This case clarified that the per curiam is well a reason for the Court of Appeal to depart from its own past ruling. Also in the case law of R.V. Taylor 1950, the defendant was charged with murder, and during the trial the judge told the jury that if Taylor had a motive to kill, then he has also had intention to kill. But the Court of Appeal disagreed and said this decision was legally wrong. The court explained that motive is not the same as intention. This case is important because the Court of Appeal showed that criminal liability depends on intention, not just motive. The court did not follow the trial judge's view because it was wrong in law and could be considered per curiam. This case clarified the law and helped avoid future errors in explaining intention and motive in murder cases. So you can see here that this whole concept was discussing about per curiam, right? So here you will get 1 marks by explaining the concept of per curiam by relating this case law. If you will add this case law that is mentioned over here, you will get 1 marks for adding the case and 1 marks for explaining per curiam with the case. Okay, and you will also get 1 marks for adding about Lord Donaldson's as well, because Lord Donaldson also had explained the same thing that Lord Denning said in the previous lines, and you should also add about this case law after explaining about Lord Denningson's. Okay, after doing all that, I'm going to go to the next paragraph. Another way in which the court may depart from absurd precedent if the previous decision is incompatible with the European Convention on Human Rights. So now I have mentioned about European Convention of Human Rights. If any of the decision that goes against or interrupts this European Convention of Human Rights, then these type of decisions may not be accepted by other upcoming judges. So basically, if there's any precedent or any kind of a decision that was made against the European Convention, at this point the future judges should not be bound to follow previous decision. Okay, so if you would add about European Convention of Human Rights, you will definitely get 1 marks from adding this point as well. Okay, under section 21A of the Human Rights Act 1998, court must take into account of decisions of European Court of Human Rights. It was done in the case of medicaments and the R.V. Gulf 1993. So basically, when you will add about European Convention of Human Rights, you will get 1 marks from adding this point, and the second point you will get from section 2(1)(a). You will get 1 marks from this as well, and after doing so you will get 1 marks for adding this case law. But if you will not explain this case law, maybe you will not get 1 marks. But if you will explain this case law in detail, that what had actually happened in this case, you will definitely get 1 marks from here as well. Okay, so this is how you have to include details of other points such as the European Convention and the section as well, so that you will get full marks. Now I will move on to the next paragraph. In the case of R.V. Simpson, a panel of 5 judges overruled the previous decision of the panel of 3 judges, and it was believed that a large bench could depart from the decisions of a smaller bench. So in this point, you have seen that I have included the case law of R.V. Simpson. In this case law, basically what had happened is that there were a panel of 5 judges that had basically overruled or did not wanted to follow the decision of the 3 judges. They thought that the panel of 5 judges is more, and they thought that they should not follow the decision of the panel of 3 judges, because they believed that a larger bench could depart from the decision of the smaller bench. So this had happened in the R.V. Simpson case. So if you would add this case law and explain it like that, you will definitely get 1 marks or 2 marks from here. So this is how you will get 4 marks by adding the case laws, by adding all the detail. Now I will move on to the next question. I have opened the next question, that is question 6b. It says, discuss whether the Court of Appeal should be able to depart from decisions of the Supreme Court. So this question is a bit different from the previous one, because in the previous question they have asked that Court of Appeal should depart from their binding precedents. Precedents means decisions. Okay, so in the first question it was like that, can the Court of Appeal can ignore their past decision or depart from their past decision? So I have made the whole answer at a different case laws with it. Okay, but in this question they have to depart from the Supreme Court. So they can depart from Supreme Court. Do they have the authority to do so, or do they have the authority to depart from it, or they can't depart from it, and why should they not depart from the Supreme Court's decision? So all of this thing is going to be discussed in this second question. It's all about gonna be for the Supreme Court. So I'm going to start this answer. Let's go straight to the answer now. I had opened up the answer now. Lord Denning, a famous judge, argued that the Court of Appeal should not be strictly bound by the decisions of the Supreme Court. So here Lord Denning said that the Court of Appeal shouldn't be strictly bound to follow the decision of the Supreme Court. He believed that law should be allowed to develop and grow, especially when the Supreme Court's decisions were outdated or unjust. So in this whole paragraph from here to here, you will get 1 marks. Why? Because you have added the name of Lord Denning and also discussed that Lord Denning said that the Court of Appeal is not strictly bound to follow the decision of Supreme Court, because he thinks that the past decision of the Supreme Court might be a bit outdated or unjust. Due to these reasons, Lord Denning thought that Court of Appeal should develop and grow. They should not be bound to follow all the outdated decisions of the past of the Supreme Courts. So this is what Lord Denning said. Now I'm going to move on to the next paragraph. Here Lord Denning is repeated, but this time I will add a case law. In the first paragraph I didn't add a case law. I just gave a short introduction of Lord Denning, a very short introduction of Court of Appeal, and that Lord Denning wanted that the Court of Appeal is not strictly bound to follow Supreme Court decision, nor they should not be backward. Instead, Lord Denning thought that Court of Appeal should develop and grow. Their decisions should be up to date and developed, rather than following the Supreme Court's outdated decisions. But in the second paragraph I also included Lord Denning, but I also added a case law of Davis v. Johnson 1979. So let's see what I had written in it. In the Lord Denning in Davis v. Johnson's 1979 was a case where Lord Denning in the Court of Appeal tried to depart from an earlier House of Lords decision because he felt it was wrong and unfair in the circumstances. So basically, Lord Denning in this particular case, named as Davis v. Johnson's 1979. In this case, Lord Denning thought that there was a bit trouble or there's something wrong in the House of Lords decision. So basically, in the Supreme Court, House of Lords give decisions. Okay, the House of Lords plays the role of a judge in the Supreme Court. So basically, the decision that was made by House of Lords in 1979, in this case, where Lord Denning was the judge. So what had happened is that Lord Denning refused to follow the decision of House of Lords, who were the judges of the Supreme Court. Lord Denning refused it because Lord Denning thought that their decision was unfair and wrong. This has happened in this particular case. Let me just clean this out. He refused that the Court of Appeal should be able to fix bad law without waiting for a highest court to act. However, when the case went up, the House of Lords made it clear that only they can overrule their own past decisions, and the Court of Appeal must follow those decisions, which has been done in Milangos versus George Frank, Textiles Ltd, 1979. So basically, this whole paragraph from here to the previous here. So basically, in this whole paragraph, Lord Denning was consistently saying that the Court of Appeal should not follow Supreme Court's decision if they are wrong. So here what had happened is that Lord Denning argued that Court of Appeal should be able to fix bad laws without waiting for the highest court to act. But what had happened is that when this case went out, which case? This case over here. When this case went out and got viral, what had happened is that the House of Lords, the judges of the Supreme Courts, House of Lords were the judges of the Supreme Court. They said that they made everything clear that only they have the authority to change their own previous decisions. So the lower courts, such as the Court of Appeal, do not have the authority to disobey them. They have to follow them no matter what the case is. But they said that they have the authority to change their previous decision. No other authority can do this. And this thing happened in this case of Milangos versus George Frank Textile. So we will see what had happened in this case law. The Supreme Court allowed damage awards in foreign money instead of only in pounds, fixing an old rule. Letting the Court of Appeal break away from Supreme Court decision might make the law quicker to improve. So basically, in this case of Milangos versus George Frank Textile, what had happened is that the Supreme Court had allowed to pay the compensation in the foreign money instead of the money in pounds. Basically, the case was from a different country. This case was, the people and everything was in different country, and instead of giving them the compensation in pounds, the amount of money was in foreign currency. Because at that time in 1979, at that time pound was not that much high. The amount of money in pounds wasn't that high. That's the reason they demanded the money in their own currency, in their own foreign currency. So the judges of the Supreme Court thought that giving compensation in their own foreign money is better than giving them in pound. So fixing an old rule. So the judges thought they should fix the old rule, because the old rule said that money should be in pounds, but the judges of the Supreme Court had fixed their own rules. So what had happened is that when the judges have fixed this rule and changed their decision, what had happened is that the Court of Appeal does not need to follow the previous decision to follow the pounds. That means that they don't have to give compensation in pounds now, because the Supreme Court themselves had changed this old rule and said that the currency should not only be bound to be in pounds, instead it can be given in foreign currency. So the Supreme Court had changed it. So now what had happened is that Court of Appeal, the lower court, is not bound to follow this previous decision. Instead, they can follow the other decision that has been changed by the Supreme Court. What decision? That decision was on that the foreign currency can be made. So what had happened is that after changing such type of decision, Court of Appeal become much quicker to improve, because Court of Appeal doesn't need to be bound to follow such decisions that can give a very wrong decision in their own cases as well. So the Supreme Court's decision helped a lot in improving the Court of Appeal. Okay, so this is how this case law helped. Now I'm going to move on to the next paragraph. Furthermore, in case of Young v. Bristol Airplane Company Ltd 1944, when there are two conflicting Supreme Court rulings, Court of Appeal can depart from its own previous decision that are conflicting if there are two previous decisions that are conflicting with each other. This case law makes it clear that if there is a conflicting case laws, then Court of Appeal is able to depart from decisions of the Supreme Court, but cannot overrule the decision, because only the Supreme Court can overrule the decision. Here I have mentioned the Young versus Bristol Airplane Company Ltd 1944. Basically, this case law was also added in question 6A. Why I had added this again in this other question? Because I wanted to clarify that in this case, the Court of Appeal can depart from two conflicting cases. If there are two cases, then the Court of Appeal can choose any one of them and ignore the other case, the other decision that is wrong. So here there are two conflicting cases, but after writing this case law and giving the explanation of it, I also had clarified that the Court of Appeal can only depart from two conflicting cases, but they cannot overrule the decision of the Supreme Court. Only the Supreme Court can overrule their decision and change their case law. Okay, so this is the thing I have mentioned in this to clarify that this case law also said that you can choose a different decision, but you cannot overrule the decision of the Supreme Court. Two decisions of the Supreme Court might be conflicting. Still, at that point, Court of Appeal can choose any one of them, but they cannot overrule any of the decision of the Supreme Court. Only the Supreme Court has the authority to change their decisions. Moreover, there are numerous reasons for why the Court of Appeal should be allowed to depart from Supreme Court decisions. For the first reason is that the cost of taking the case to the Supreme Court is so high that all the cases go straight to the Court of Appeal. Hence, if they are not given the flexibility of judicial creativity, the law will fail to develop according to the social and economic changes. Since a case is rarely reaches the Supreme Court for them to depart from old and unfair decisions. So in this whole paragraph, I said that the Supreme Court cases are mostly really costly. If anyone wanted to go straight to the Supreme Court for their case, so they have to pay a lot of charges. So that's the reason a lot of cases don't go to Supreme Court. Instead, they go straight to the Court of Appeal. That's the reason the Supreme Court cases do not evolve or change. All the cases go straight to a Court of Appeal, but Court of Appeal has to follow the Supreme Court's decisions, and after all, a lot of cases are not going in there. Instead, they are going to the Court of Appeal. So the new cases are going straight to the Court of Appeal. That's the reason that the Supreme Court is not changing their previous decisions due to the lack of cases going into it. Instead, all the cases are going into the Court of Appeal. The new upcoming cases are going there. That's the reason the Court of Appeal wants to match their new cases with the previous ones. But Supreme Court is not changing because the cases are not going that much. That's the reason they thought that less cases are coming. Why needing to change it? That's the reason the Court of Appeal wanted to not follow the same decision, and they wanted to depart from it. But no, this will not happen because Supreme Court has the authority to overrule the decisions. No other authority can overrule the decision of the Supreme Court. So in this whole paragraph, I've said that if Supreme Court cost can be decreased, it will help the Court of Appeal and all the other courts to be more active, because if the Supreme Court is getting a lot of cases, it will be up to date in decisions. All of their upcoming decisions will be up to date, and they will also recheck their previous decisions as well, and that will help the lower court, because all of their decisions will be binding to the lower courts, just like its decision is binding to the Court of Appeal. So if their decision is binding to the Court of Appeal, and the Supreme Court itself is helping Court of Appeal by changing the decision, making their decision up to date, this will help a lot to the Court of Appeal to perform their duty. But as we all know that the cost in Supreme Court is really high, that's the reason the law is not developing, the laws are not being changed, because the Supreme Court has the authority to make decisions, and those decisions are converted into precedents, and then they become binding on the lower courts. On these precedents help in making the laws. So if Supreme Court is not participating in changing laws and making more precedents, then the law will not develop, the law will not be up to date. That's the reason the Supreme Court need to take more place in changing laws and making them up to date. So I'm going to start the next paragraph now. The Court of Appeal should not be able to depart from Supreme Court decision, because the English legal system follows the structure of hierarchy, and if the Court of Appeal departs from the decision of the Supreme Court will no longer be considered the highest court of hierarchy. Furthermore, the judges of the Supreme Court are given respect due to their seniority, hence their legal decisions are to be followed, and if the Court of Appeal is above to suppress these decisions, then this system of respect will be disrupt. So basically in this whole paragraph, the respect of Supreme Court is discussed, that Supreme Court is the highest authority and the Supreme Court contains the system of hierarchy. So basically this whole system comes from the English legal system. So if the Court of Appeal does not obey the Supreme Court's decision and overrules them or suppresses them, then ultimately what will happen is that the respect of Supreme Court and the seniority of the judges of the Supreme Court will be decreased, and it will disturb the whole system of the legal system in UK. Now I'm going to discuss the conclusion. In conclusion, while Lord Danning's call for the Court of Appeal to depart from Supreme Court decision highlights the need for the law to stay fair and up to date, our rules, especially the young exceptions, make clear that only the Supreme Court can truly overrule itself. So basically, in conclusion, I have written down that Lord Danning was the main person that had highlighted that the Court of Appeal can depart from Supreme Court decision if they wanted their decision to be fair and up to date. And he also included that in this Young's case, okay? But the Supreme Court also had clarified that they are the only one that can overrule their previous decision. Allowing the Court of Appeal to ignore higher court ruling might speed up legal change, but it would also create confusion, weaken the court hierarchy, and undermine respect for our top judges. So if we allow the lower courts to ignore the higher court's ruling or higher court decision, it will ultimately lead to confusion and weaken the court's hierarchy and decrease the respect of top judges of the Supreme Court. For these reasons, most people believe the Court of Appeal should follow Supreme Court decision and leave any real departures to the highest court. So basically in the last ending line, I've mentioned that the Court of Appeal must follow Supreme Court, but if there's any kind of a mistake or wrong included in that decision of the Supreme Court, then the Court of Appeal should leave that confusion or disturbance of the decision to the Supreme Court's hand, because the Supreme Court has the authority to change their decision. So it's the duty of the Supreme Court to change the decision according to the up-to-date system, according to the fair system. Okay, so this is what I have included. So if you will write your answer like this, including with the case laws and all the names of the people like Lord Danning and the other people, telling about the cases properly, then you will definitely get full marks in this. Now I will start my other question. Our other question is question number 7. Question number 7A. Describe the rights of suspect detained at police station. So in this question, you have to write the rights of the suspect that is detained in police station. You're not going to write only the rights name. You just don't have to, write the names and you will think you will get full marks or maybe 2 marks. No, that's not it. If you will only write the right's name, you will barely get 1 mark or maybe hardly -2 or something like that. Okay, but if you will include the whole detail that why the suspect got these rights and which authority given them these rights, if you have mentioned these names properly, made a longer answer of 1.5 page with adding all the reasons for right, with adding the reasons for a person to be detained, and which authority gave them the authority to power to have rights, and which authority gave the police station the authority to arrest them. You have to add all of these things in your answer. Okay, so I'm going to start the answer now. So I have opened up my answer. This is answer 7A. The rights of a suspect detained at the police station are given under the Police and Criminal Evidence Act. Now, after adding the name of the act, you will definitely get 1 mark from here. Because if you are mentioning the authorities that this act is the main thing that is giving a suspect a right, this is why you will get 1 mark. Now I'm going to the next line. This act contains different code, where code of C deals with detention, treatment and questioning suspect during their detention in police station. Now you will get 1 more marks. Why? Because you have added the code C, because remembering different codes is the most important thing. So if you memorize that the Police and Criminal Evidence Act contains a code C, and that code C contains detention, treatment and questioning a witness or a suspect, if you have clearly mentioned this in your answer, you will definitely get 1 more mark from here. So you will get 2 marks from this. Why? Because you have added the name of the act that have given the rights to the suspect. This is the authority that given the right to the suspect, and you will get 1 more marks by adding the code C and telling that the code C contains detention, treatment and questioning. That means the code C of this act over here contains detention, treatment and questioning details of a suspect. Okay, after doing this you will definitely get 2 marks. Now how will you get more marks? We will continue the answer, then you will know. Suspect has a right to have someone informed of the arrest is mentioned in section 56 of this act, and the detainee is free to nominate any person who may deal with the police and handle their situation if the detainee is a minor or a disabled. So basically now you will get 1 more marks. Why? Because you have added the section 56. After adding this section you will definitely get 1 marks. Why? Because you have mentioned section 56 and also told that this section contains that the detainee is free to nominate any person who may deal with the police and handle their situation if the detainee is a minor or disabled person. So basically the line that starts from here to here is all about that is mentioned in section 56. So if you include section 56 and also tell that this section contains that the detainee is free and all of this from here to here, you will definitely get 1 mark from here. Now I will continue my answer. This rule may also apply to normal citizens for having an appropriate adult informed. So basically, when you will move to another line, you also have to say that this section over here, it is a rule that allows or applies that a normal citizen has the authority to have a proper adult informed. Suppose if that citizen is went to police station and that person does not have the knowledge to deal with police, to deal with the people in the police station, so that person has the right to call anyone who is an adult to deal with that matter. This is discussed in the case of RVS Spinal 1999. So now by adding this case you will get 1 more marks. Why? Because you have added this case and related with this section, and you will also explain this case as well. So if you will explain this case, you will ultimately get 1 marks. So in this full paragraph you will get 2 marks. Why? You have added the section and explained the section from here to here. After doing that, you have added the case law and then you have explained this case law from here to here. You will get 2 marks, one from the section and one from the case. Now I will explain the case now. In this RV Espinal 1999, where a man named Espinal who suffered from schizophrenia arrested by the police. He was questioned without a reasonable adult or guardian called an appropriate adult. Present according to the law, when someone has a mental disability or is mentally vulnerable, the police must make sure an appropriate adult is present during interview to protect the person's right and ensure fair treatment. Later, Spinal confessed to the crime, but his lawyer argued that the confession should not be used in court because it was not obtained fairly since no appropriate adult was there. The court agreed and ruled that the police had broken the rules of the Police and Criminal Evidence Act of Code C, and the confession was unfair and unreliable. So the confession was not allowed to be used as evidence. So in this whole case was discussed that the particular person was suffering from a illness, and due to that illness there was no appropriate adult available, and that person have given evidence to the police without having a proper adult. So due to this reason, the lawyer of this particular person said that there was no adult. Due to this reason, the police did not have the right to ask questions from someone that is already suffering and he is not mentally stable. So that's the reason the court said that the police had broken the code C, because in code C it was mentioned clearly that the person who is arrested has the right to call anyone that is a proper adult to be available at that point when the witness is being asked different questions from the police. So at that point no adult was available. That's the reason the confession that was made by that person will not be used in court as an evidence. So that's it for this paragraph, and you will definitely get 1 to 3 marks only from this paragraph because you have properly added all the detail of the case, you have properly mentioned all the courts, you have properly mentioned the acts. So you will definitely get 3 marks from this paragraph. Now I will go to the next paragraph. Second right of suspect is to have the legal advice by solicitor, which is given in section 58 of this act. So after adding section 58 and after telling about what had mentioned in section 58, you will definitely get 1 marks. So basically in section 58 it was mentioned that every suspect have legal advice by solicitor. So this line is mentioned in section 58, so you have to remember it while attempting this answer. As mentioned in the case of R.V. Samuel in 1958. So after getting 1 marks from adding section and telling the name of the section like that, you will get 1 marks, and the second mark you will get from this case by telling the detail of this case. After writing the case, you will tell the whole detail what had happened in this case. So I will continue the case now. Samuel was arrested by police and asked for a lawyer, but the police refused to allow him to contact one. This said it was necessary to stop others from being alerted. Later, he confessed to the crime during questioning without legal advice. The court said this was wrong and unfair. Everyone has a right to speak to a lawyer, especially after being arrested. The judges ruled that refusing a lawyer without strong and real reason is against the law under PAC Police and Criminal Evidence Act 1984. So the confession was not allowed in court because it was collected unfairly. So from here to here, we have discussed the case of R.V. Samuel 1988. So in this whole case, you have seen that Samuel was not given a right to have a legal advice from a solicitor or any lawyer. That's the reason the evidence that was given by Samuel was not accepted by judges. Instead, the judges said that the police did not follow the section 58 of this act, PAC Act. That's the reason the court said the police had disobeyed and did not follow this act. So you will also include R.V. Grant 2005. After adding this other case law, you will definitely get 1 more marks. So in this other case law, what had happened, I will discuss the detail now, where Grant was accused of being involved in serious criminal activity while he was in police custody. His private conversation with his lawyer were secretly recorded by police. This was done without permission and was a violation of his legal right. The court said this was a serious breach of right to a fair trial. A suspect must be able to talk privately to their lawyers. Because of this secret recording, the trial was considered unfair and the conviction was overturned. So basically in this case what had happened is that the police did not told the witness, the suspect, sorry. So the police did not told the suspect that they are being secretly recorded. If they have told them properly that their voice with their lawyer is going to be recorded, then it will not be considered unfair. But the police had not properly informed about this thing, about secret recording, to the witness, I mean to the suspect and their lawyer. That's the reason their witness or their all evidence they have recorded was not considered a right thing. It was against fair trial. So this case is also suitable to add. You will get 1 marks from adding this case. Now I will move on to the next paragraph. Moreover, under section 76 of this act states that the court shall not allow statements that have been obtained through oppression or force, including torture, inhuman treatment, or use of threat of violation, to be used as evidence. So in this other paragraph I've said that section 76 of this act said that the court shall not allow statements that have been obtained through oppression. So this section discusses oppression. Said this section said that if there's any kind of evidence that is obtained through oppression or force or any kind of a torture or inhuman treatment done on the witness, or any kind of a threat violation done on the witness, that at this point no evidence such that is obtained from these things cannot be accepted in court. That evidence will not be accepted. So this section highlights these things, and this is kind of like giving a witness a right, because that suspect or a witness will get proper rights by this section, because this section stops the police from using oppression, force, torture, inhuman treatment, or use of force to get the evidence. Okay, so now I'm going to move on to the next paragraph. So the next paragraph is the conclusion, where you have to wind up the answer. In conclusion, the Police and the Criminal Evidence Act 1984 PAC gives important rights to suspect at a police station to make sure they are treated fairly. So you have to repeat the same line here, that this act gives rights to the suspect in police station so that they can be treated fairly. Then you have to include that these includes the right to have someone informed of the arrest, the right to legal advice, and the right not to be forced or threatened into giving a statement. From here to here, you will include the same wordings, that these rights have included that no person will be arrested without having a proper adult. They should have a proper legal advice with their lawyer or solicitor, and no one should be threatened or forced. Also include all those cases like that, like you have to include R.V. Espinal and R.V. Samuel or R.V. Grant clearly shows that if the police do not follow these rules, any evidence or confusion may not be accepted in court. So in this case, after adding all these cases, you will say that if the police is not following the rules mentioned in the act, then the evidence that is obtained will not be accepted in court. These protections help ensure fair treatment and a fair trial for all suspects. So these protections, which protection? The protection given in this act in section 57 and all these sections and all these cases ultimately helps the suspect to be treated fairly. This is enough for this question. Now I'm going to move on to the question B. 7b, it says discuss the extent to which these rights protect the suspect. So basically in the other question, this one you have to tell that at what extent these rights can protect a suspect, where you have to tell that how much the PACE Act and the European Convention Act protects a suspect from police stations' cruelties. So I'm going to start the answer now. I have opened up question 7b. Now I'm going to start the answer. The Police and the Criminal Evidence Act 1984 contains codes for practice that can ensure the process of arresting someone or can search them in right. The rights of a suspect at a police station are mainly protected by the Police and Criminal Evidence Act 1984. So basically, in the start, you have to write the act name, that the Police and Criminal Evidence Act. In short, it's called PACE. You have to tell about this act in the start, that this act protects the right of the suspect, that has been arrested, or that person who got recently arrested. So they get the rights from this act. Furthermore, you have to say that the rights of a suspect at a police station are mainly protected by the Police and Criminal Evidence Act 1984. First of all, you have to tell that this act contains different codes that ensures that all the people who are arrested will get rights. Okay, after telling that, then in the second line you have to say the rights of a suspect are included in this act of Police Criminal Evidence Act 1984. This is how you have to write your answer. This act aims at protecting or providing rights to suspect as well as rights to the police. So this act basically not only helps the suspect only, but it also helps the police as well, where sometimes suspects interfere with police and do not let them search. So this act also provide help to police as well. After doing so, you have to continue your answer by Article 5. Article 5 of European Convention on Human Rights, ECHR, requires that there be a lawful authority on suspicion of having committed crimes. So basically you have to say that the Article 5 of the European Convention of Human Rights requires that there should be a lawful authority that should arrest a person. Okay, no other person, no one out of nowhere can arrest a person. There should be a lawful authority. The people, the authorities, the police must be legally entitled to arrest a person. Furthermore, arrested persons should be informed why they are arrested on the language that they may understand the reason for arrest. Suppose if a person who cannot speak English or cannot speak the language of the country, if the police is arresting them, so it is their duty to explain the reason to the person that is being arrested. They should tell them the reason why they are being arrested, even though he cannot understand the language. So it is the duty of the police to explain that person in their own language so that they can understand why they are being arrested. So this is how the rights are being protected in Article 5 of European Convention on Human Rights. Now we will see a case law. In this case of R.V. Halliwell 2012 EWCA crime 1153. In this case, Christopher Halliwell was arrested on suspicion of involvement in woman's disappearance. Instead of taking him to a police station and following proper procedures, a senior officer, Detective Superintendent Fletcher, questioned Halliwell at a remote location without offering him access to legal advice or informing him of his full rights. During this unlawful questioning, Halliwell confessed to the murder of 2 women and led the police to where the bodies were buried. However, the court ruled that the police had seriously breached the rules set out under the Police and Criminal Evidence Act 1984 PAC, especially the rights protected under Section 58 of PAC. So basically in this whole paragraph, the case is being discussed where a person named as Halliwell, this person over here basically had been involved in the disappearance of a woman, and he said that he had disappeared not only 1 but 2 women. But the problem here is that the police who had arrested him did not give him the access to legal advice, nor did he informed him about his full rights. As mentioned in the PAC strictly informed the police that whoever is been arrested, they have the right to get a legal advice from a solicitor, or they can also tell them about their other rights as well, that other rights such as having an adult with them if they can't understand the case, and the other things we have already discussed before. So all of these rights must be informed by the police to that suspect, but in this case the police did not informed that suspect named as Halliwell about all the rights. That's the reason, even though Halliwell accepted that he had did a crime, he had buried their bodies, and also the bodies were found, yet police did not follow the proper procedure as mentioned in PAC. That's the reason the court refused the evidence of the police against Halliwell. Okay, this thing happened in this case. Under section 58, which gives a detained person the right to consult a solicitor privately at any time. By detaining Halliwell, this right before questioning him, the confession was obtained unlawfully. The first confession about the first murder was therefore excluded from evidence, while the second confession about the second murder, made later under proper legal conditions, was accepted. This case emphasized the importance of respecting the suspect's legal right during the investigation. So in this whole paragraph, you can see that section 58 of PAC will give you 1 marks, because this section helps the suspect to get legal advice from solicitor. From here you can get 1 marks. Furthermore, if you have mentioned this whole case of Halliwell, you will also get 1 mark or maybe 2 marks, because this case, if you're explaining this case including you're also explaining the section, you will definitely get 3 to 4 marks only from this paragraph after explaining properly the case, after explaining properly the section. So this section is properly explained from here to here, where I have said that section 58 of PAC explains that detained person have the right to consult a solicitor. Okay, so if you have explained the case and the section properly, then you will definitely get 4 marks in this. Additionally, section 10 of PAC protects legal professionals' privilege, meaning that any private communication between a suspect and their lawyers cannot be used as evidence. The case of Halliwell is significant because it shows that even clear confession may be rejected by the court if police officers fail to follow proper legal procedure laid out ensures fair treatment. So basically the section 10 here elaborates that every professional legal expert has the right that they can talk to their suspect or talk to their client privately. That means that a lawyer, if the lawyer is handling a client who is a suspect of a police, then that lawyer and the client can have a private communication. No third person can be involved. This is provided in section 10 of PAC. Through this section, we get a proper right for a suspect. So you will also get 1 to 2 marks from here as well. Paragraph I've added the same case that I have added in the previous question. This was RV Espinal 1999. In this case, RV Espinal 1999, the court looked at how the police should treat vulnerable people during arrest and questioning. Espinal was a mentally ill person who was questioned by police without appropriate adult present, even though his condition showed he clearly needed support. According to section 56 of the Police Criminal Evidence Act 1984, anyone who is arrested has a right to someone informed about their arrest as soon as possible. Also under PAC Code C, if a suspect is mentally ill or vulnerable, the police must make sure that an appropriate adult is with them during the interview to protect their rights. In Espinal's case, the police failed to follow these rules. Because of this, the court decided that this confession could not be used as evidence, as it was unfairly obtained. This case showed that police must follow the rules under PAC, especially when dealing with vulnerable people, to make sure the process is fair and legal. So you can see that we have already discussed this case in the previous question, that Espinal was a person that was suffering from a disease, and due to that he is not capable to perform like normal people. That's the reason that person really needed someone like an adult who can handle police questions. But here he did not get any of the adult help, nor did the police supported them, nor did the police helped him out, nor did the police told him about the rights. That's the point where the police did not follow the PAC rules and their evidence got rejected. So this is more important as well, so you can also include this case law again in this answer, because this case law is very important for this answer, so it will give you 1 to 2 marks as well. Now I'm going to my next point. In the case of Taylor versus Chief Constable of Thames Valley Police 2004, the court looked at how police must follow Code of Practice G under the Police and Criminal Evidence Act PAC 1984. Code G covers the police powers to stop and search people and vehicle. Taylor argued that the police stopped and searched him without proper legal grounds and did not follow the correct procedures in Code G. The court agreed that the police must always have a reasonable suspicion before stopping and searching someone and must explain clearly why they are doing it. Also, the police need to give the person a written record of the search. This case shows that the police cannot stop and search anyone without good reason, and if they do not follow Code G properly, the search may be unlawful. It protects people from unfair or random searches by the police. So this whole case over here that was mentioned here about Taylor, Chief Constable of the Thames Valley, in this case basically what happened is there were a few people that were traveling in a car. Suddenly police stopped them and told them that they were searching the car, and they did not mention any reasonable reason that why they are searching. That's the reason that even though if police found out any kind of evidence, yet their evidence might be rejected by courts because the police did not follow the PAC rules. That's the reason this case law is very helpful for your answer, because it is supporting the rights of suspect. And now I will move on to my other question, but before going to the other question, I want to mention the conclusion. Conclusion is really important because it is kind of like a whole mixture of your answer, and it helps promote giving you good marks as well. So in conclusion, you have to combine the whole set of your answer in short. So I will read it, you will understand it. In conclusion, the rights of suspect under the Police and Criminal Evidence Act PACE and related codes, along with protection under the European Convention on Human Rights, provide important safeguards to ensure fair treatment during arrest, questioning and search. Case like RV Helville, RV Espinal and Taylor versus Chief Constable of Thames Valley Police highlighted that police must follow legal procedure carefully, especially respecting access to legal advice, protecting vulnerable suspects, and conducting searches lawfully. When these rights are ignored or breached, evidence may be excluded and suspects are protected from unfair treatment. Overall, these laws and cases demonstrate the crucial balance between effective policing and protecting individual rights. So basically in the last conclusion, I have combined my all answer and gave a proper answer that was asked in the question. So I think that's it for this question. Now I'm going to the other question, that is question 8. Eighth question opened. 8th question A. Explain how inferior judges are selected and appointed. So this is for 10 marks and we're going to start it now. Now I'm going to open my answer. So the answer is open and I'm going to explain it in detail. Inferior judges such as the circuit judge, recorder and district judges handle cases in lower courts like the Crown Court, County Court and Magistrate Court. Their appointment and training are overseen by judicial colleges, which make sure that all judges have the required legal knowledge, practical judicial skills and an awareness of the social environment they operate in. New judges must attend a residential induction course that lasts between 3 to 5 days, and they also given mentors to guide them at the start of their judicial career. The Constitutional Reform Act 2025 ensures that the judicial appointments are based strictly on merit and also protects the independence of the judiciary. The Judicial Appointment Commission is responsible for assessing candidates and selecting them for judicial posts. No one can be appointed unless they have been recommended by the Commission. In addition, the Commission consults the Lord Chief Justice and other experienced judges before putting forward a recommendation for appointment. So basically in this entire paragraph, I have written about the inferior judges' qualification and their appointment method. So basically the inferior judges from the circuit judges, the recorders, the district judges, all of these judges are handling the lower level cases, and these judges sit in crown court, county court, and magistrate court, and their appointment and training is properly done in judicial colleges, and they get proper knowledge, practice of judicial skills, and awareness of their social environment as well while studying in judicial college. New judges must attend residential induction that lasts for like 3 to 5 days. Furthermore, they also get different mentors, some senior judges that will work with them in order to help them understand about their career. Their appointment are done on merits. After getting their appointment done by merits, the judicial appointment that is kind of like responsible for all of this, they are responsible to conduct the appointment and doing everything. So the judicial commission will select all the judges, but before selecting them, they will recommend these judges to the commission. But commission will do is that commission will consult Lord Chief Justice and other experienced justices before appointing them on their post. This is how their appointment shall be done. Now I will read more things about it. Moreover, during their appointment, the appointing authorities check the candidate that they must contain good character, good decision making abilities to understand and deal fairly, having good communication skills, and must be effective. In the case of R. Graham Stotts Jones versus Judicial Appointment Commission 2014, Graham Stott John, who was a solicitor and a part-time judge, applied to become full-time district judge. His application was rejected by the Judicial Appointment Commission (JAC) because he had 7 penalty points on his driving license from 2 traffic offenses, one for speeding in 2010 and another for going through a red light in 2012. So basically, due to these reasons, this judge did not get the appointment because in his past he had committed 2 penalties or 2 wrongful acts. That's the reason he did not get the position of a judge appointment for it. The JAC had a rule that anyone with more than 6 penalties points from more than one offense would usually not be appointed as a judge. Mr. John went to court and said this rule was unfair and wrongly applied in his case, especially since other judges with similar offenses were allowed to continue working. However, the court said the JAC had the right to set such rules to make sure the judges are of good character and to protect public trust in the legal system. The court dismissed this case but said he could try applying it again in future. So basically, this whole case is very important in this topic because this case helped us that judges should have more good character and they should not have any kind of a past bad thing they did in the past. So I'm going to read out the conclusion. In conclusion, the selection, you can add the heading, but it's better to not add a heading, so you can just skip the heading and directly write your answer from conclusion. In conclusion, the selection and appointment process for inferior judges is carefully structured to ensure only qualified, capable, and trustworthy individuals are chosen. The Judicial Appointments Commission plays a central role in assigning candidates purely on merits, while also consulting senior judges to maintain a high standard. Training by the Judicial College further ensures that the appointment judges are well prepared for the rules. The case of R. Graham Stott Jones versus Judicial Appointment Commission 2014 highlighted how the JAC applies strict criteria such as good character to maintain public confidence in the judiciary. This thorough and merit-based system ensures that the inferior judges are fairly and appropriately selected to uphold justice in lower court. So basically, the conclusion has the mixture of the entire answer. We have added the case law again and told that in this case law, we have seen that having a good character is very important. 8B. So let's read out the question first. Assess the advantages of process governing the selection and appointment of inferior judges. So basically in this point we will see advantages of the process governing the selection and appointment of inferior judges. Let's see the answer. This is the answer of this last question. I'm going to read out and explain to you everything in detail. The processes used for the selection and appointment of inferior judges, such as the circuit judge, recorder, and district judges, have several advantages that ensures the quality of fairness of judiciary. So basically, the process for selecting and the appointment of these inferior judges, who are the inferior judges? The circuit judge, recorder, and the district judge. These are the inferior judges. So their process and selection process and appointment process has several advantages. One major strength is that appointments are based strictly on merit as guaranteed by the Constitutional Reform Act 2003. So basically, the Constitutional Reform Act 2003 had made rules that all the judges that are going to be appointed will be appointed on merits, and this is strictly added in this act. This helps prevent favoritism or political interference and supports the principle of judicial independence, which is vital for fair legal system. So basically, favoritism means that no person is going to be selected only because they're someone's favorite, nor do political interference can be involved, because there's a strict merit in appointing all the judges. So if there's strictness of merit, then it's obvious that the judiciary is independent of all the biased system, and it is very important as well. Now the next paragraph says that another advantage is the involvement of Judicial Appointment Commission JAC, which independently assesses candidates. No candidate can be appointed unless recommended by the JCAC, ensuring a transparent and fair selection process. So basically, the involvement of this commission is very helpful because they independently check all the individuals, all the candidates, and no candidate can be appointed unless they are recommended to the JAC. Okay, because JAC is helpful in making all the appointments transparent and fair, because if appointment of commission did not gets involved, then there's a high chance that there would not be fair appointment. So their involvement is really important in order to get fair appointments and fair selections according to their merit. The commission also consults with the Lord Chief Justice and other senior judges, adding further expertise and checks before making recommendations. So before the appointment selects any person on any post, instead doing it themselves directly, they take consultation with the Lord Chief Justice and other judges having more experience as well, in order to know that which judge is suitable to work as a judge and which candidate is not. So this helps in order to get more better result of judiciary. This system builds public confidence in the judiciary by showing that judges are selected fairly and objectively. And the last line I've included that this system ultimately brings a lot of public confidence in judiciary, because every selection is based on fairness and justice. That's it. Now I'm gonna move on to my next point. In addition, the Judicial College provides professional training for newly appointed judges. These include a 3 to 5 days residential induction course and the assignment of a mentor, which helps new judges develop their skills and adjust to their responsibilities. So basically, in this next line, what happened is that whenever a judge is selected or wanna be selected, what they do is that they go to a judicial college, and in the judicial college they get a proper training of being a judge. So when they go to judicial college, they get proper training of being a judge, and they pass the 3 to 5 days of residential induction course. And then while they are working as a while they are understanding their course, they are also assigned a senior judge to help them out to understand their career, because the senior judge will also guide them about how to perform their duties. This helps supports them in developing their skills better and making them more responsible while making their decisions. This supports ensures that judges are not legally knowledgeable but also understand the social context of which they work, helping them to make balanced and informed decisions. So basically, if they are working with a senior mentor and they are properly educated in a judicial college, this helps them to make to become more better judges. This helps them to make more better decision, and due to this knowledge they ultimately get more social context means they will get a good social knowledge as well in order to become more better judge. So I'm going to move on to my next paragraph. Candidates are also assessed for key qualities such as good character, decision-making abilities, fairness, communication skills, and efficiencies. The case of R. Graham Stone Jones v. Judicial Appointment Commission 2014 shows how serious JAC takes the character requirement. Mr. John, who was a part-time judge, was denied a full-time post because he had 7 penalty points from traffic offences. Although he challenged the decision, the court supported the JAC rules, stating that such standards are necessary to protect public trust in judges. So basically, I have added this case law and said that having a good character in a judge is very important. And in this whole case, what had happened is that Mr. John, he wanted to become a judge, but he cannot become a part-time judge because he was rejected for being a judge because his past life where he had committed different offenses. Due to his offenses, he cannot be a judge according to the JAC, because according to JAC every judge must contain good character. So this is added in this case. So in the conclusion you have to write, in conclusion, in summary, the selection and appointment process for inferior judges has many strengths. It is merit-based, independent, and transparent. It includes through thorough training and character assessment. These measures help ensure that only qualified, fair, and trustworthy individuals become judges. As shown in the Graham Stott John case, high standards are constantly applied to maintain the integrity and credibility of judicial system. So basically, in this conclusion, I have combined the answer in short and added that the selection and appointment is really important thing, because during the selection process, all the selection is on merit based. Furthermore, all of these judges go through a training and they are properly checked that their character is good or not. And I have mentioned the case law as well, because this case law also highlights the importance of having a good character, because if a judge has good character, then the people or the citizen will have more trust on judiciary. So this is how you have to write your whole answer. So thank you for watching, and I'm going to upload more videos of this. Thank you, and don't forget to subscribe.